Hey there, Scott Shoemaker here, and I am an estate planning attorney in Cedar Rapids, Iowa, and I hope you are having a great day. One of the questions that I get asked fairly frequently is, what happens to my assets when I die? And there are a number of factors that play into this answer. So the first question is if you have any estate planning documents in place, such as a will or a living trust document. If you have those in place, assuming that they are valid and validly executed, then your assets will be distributed in accordance with those wishes, assuming, of course, that there are no valid challenges, and challenges to estate planning documents are fairly rare. The more interesting and more difficult question comes with the question, what happens to my assets if I die without having any estate planning documents in place? And the good news, more or less, is that the state of Iowa has a plan for what would happen to your assets should you die without a will or other estate planning documents. And it kind of depends on your situation. So, for instance, if you die and you are married at the time of your death, and all of your children are children of the spouse at the time of your death, then your spouse will inherit 100% of your assets. Similarly, if you are not married at the time of your death, so if your spouse has passed away, or you are divorced, and you have children at the time of your death, then your children will inherit all of your assets, typically divided into equal shares, and so each one inherits roughly the same value of assets. It gets a little bit more complicated under more complicated situations. So what would happen if I have no spouse and no children at the time of my death? Well, then what happens is your parents, if they are still living, would inherit your estate. If your parents are not living, so you have no spouse, no children, and no living parents at the time of your death, then your estate would be divided among your siblings. What happens if I have a spouse and I have children from more than one partner? Then this begins to get a little bit more complicated, because the estate then begins to divide. And your spouse inherits one half of your real estate and at least one half of all of your personal property, so that's everything except real estate, so long as it's at least $50,000. And then your children would inherit everything else. If you have, what happens if I have children and grandchildren, but one of my children has not survived? Then what would happen is that child's share would be divided among their children. So if you have 2 children and you have 4 grandchildren, so each of your children has 2 grandchildren, for instance, and one child is still living and the other child is deceased, then your child will receive one half of your assets, and your 2 grandchildren that are the children of your deceased child each will receive 1/4 of your assets. So you can see how this gets fairly complicated fairly quickly, and of course this does not take into account and no person other than family will automatically inherit under the law. So close friends, unmarried partners, anyone that's not a direct blood relative of yours will not inherit under the law unless you specifically provide for them in some sort of estate planning document. So hopefully that helps you understand what happens to your assets when you die. Have a great day.